Hang on a second. Okay. And also there has to be at least a statement regarding a meritorious defense in the case. All right.
Your Honor, I'm not an attorney, so I'm not really familiar with the terms that you are using, but I did let you know that I did seek counsel, and I will learn how to be an attorney by the time the end of this meeting.
Okay, well, you don't have to be an attorney. I have to state it the way that it reads. I can state it in very simple form. In terms of the default was entered on August 13th.
Yes.
Why weren't you here on that date?
I was there on August 13th. I was actually flying into Michigan, and I did tell that to the magistrate, the attorney. She missed the court date. No one wants to miss a court date, Your Honor. So I was actually coming through the airport, and before I landed, I did call the attorney Cox, and I did call the apartment complex, Miss Tanisha, and neither one of them was able. I also called the court and asked to get a reschedule, but at the time they said there was nothing that they could do. So because I'm not an attorney and I don't know what to do, I've been in my 20 years, I've never been late. For this issue to cause me to be evicted, and I'm really kind of shocked and so I had to learn this process on my own, you know, trial and error. So I did explain to
How much? Hang on one moment. There was $2,115 owing in August. What is the current balance?
$5,194, Your Honor.
How much?
And I asked her, how did she come up with that number?
Ma'am, I can't hear 8 people at once. Okay. What was the amount, Ms. Hart?
Judge, $5,794.
All right. All right. And ma'am, obviously you dispute that amount?
Your Honor, the original amount is $2,111. That is the part I'm talking about today. I don't know. When you asked her, I don't know where she got that number from.
Well, has any rent been paid?
Yes, some rent has been paid.
Judge, if I may.
Yes.
No money has been paid from Ms. Davis since July 10th of 2025. There was a check for $257. Since then, Judge, there has not been a payment. Her rental amount did increase, Your Honor. It went from $256 to $1,049. So I think that's where there is a discrepancy in her mind where
is that because of a lack of certification on this?
That's what it looks like from my cursor. Looking at the case notes, that is correct.
All right. And ma'am, why haven't you, what do you say has been paid?
The portion that's the Section 8 has been paid, and because I don't know what my amount is, Your Honor, I didn't know what to pay. And because I didn't understand what, with not waiting to get services or get answers or get responses from the so-called services that we have, they were all denied after requesting 3 and 4 times, I guess, because the government did shut down. And so now that some things are open, I can go back and reapply. But I do have the $2,000 that they're asking for, except I had to ask for this motion so that I'm not evicted and I can have some time to take care of whatever else didn't get taken care of. And that is what I'm asking for. Some time to get this taken care of. I can honor the judgment because I missed the court date, but it wasn't because I wanted to miss.
Judge, here's plaintiff's position, if I may respond. Motion is quite untimely, Judge. This judgment was taken back on August 13th, and she filed her motion October 13th, Your Honor. And only after we posted a notice that the writ would execute did she come to court. She hasn't contacted us since then. Hasn't pardon, Judge? Did you? Oh, sorry. So, Judge, she sat on our hands. It's October 13th. We have an extremely high balance. although she can satisfy the judgment now, it's quite untimely. I'm asking for the motion to be denied.
But if she tendered the judgment, then if she tendered the judgment amount, she'd satisfied the judgment.
That's why I'm here.
I mean, I agree with you, Ms. Hart, that she would still owe a balance, but she says she can satisfy the judgment.
Judge, but from the statute, it doesn't permit a late payment. And actually, the judge's case law against expanding the time for a redemption period that's set forth in the judgment.
Except that there's other case law which clearly indicates that landlord-tenant proceedings, particularly non-payment ones, are remedial in nature as opposed to a mortgage foreclosure, which is not. So if we want to have a battle of case law, we can have a battle of case law. I think I know who will win.
Judge, I don't think that the threshold has been met for good cause to set it aside. It doesn't sound like there's a defense that she doesn't owe it's just more time, and our plaintiff would object to that.
But what I'm getting at is that if she has the money and tenders it, she satisfied the judgment, and I would indicate that plaintiff would then be precluded from going forth with the writ. Whether I grant or deny the motion, well, if I grant the motion, the judgment's not there. But if I deny the motion and she were to pay the $2,000, I think she satisfies the judgment prior to the execution of the writ. So, and that may be a battle for another day. But what I'm not hearing here from you, ma'am, is I'm not hearing a meritorious defense to the claim or anything that comes close to that. You have the amount that the judgment is and can tender that amount to the landlord, but that doesn't prevent them from coming right back in with another case for what effectively is going to be September and October and possibly even November.
But those amounts have been paid, Your Honor. The only part has been not paid is my portion. And once I know what my portion is, Your Honor, I'm going to honor that. I do not wish to move.
Well, I understand that, ma'am.
But I will move. I will move. I can move because at this point, I probably will move. Because, I don't think that after 20 years of paying someone rent and this is how they treat me because I'm late, then I don't need to be here. But I do ask the court to at least give me my opportunity to do that.
To do what? To move? Well, I'm not going to do it that way. I've got a motion before me to set aside a default. The requisite things of good cause and a meritorious defense to this court's satisfaction have not been shown. The motion is denied. Now, what I will indicate, if you want to listen to me, is that the amount of the judgment, if the amount of the judgment is tendered, then this court, or at least I would, deem that the judgment is satisfied. And then that would be fine. And you may have to fight about the next 3 months, but that's
There's no fight. There's no fight. I don't want to fight, Your Honor.
Ma'am, are you listening to anything I am telling you?
Yes, I am.
No, I don't think you are. What I'm indicating to you is that the judgment was for what, $21.15. All right. You're telling me you have the amount to satisfy the judgment.
I'm just getting that amount.
I'm not going to be interrupted. You're always interrupting me. I'm done. I've tried to explain it to you. You need to.
Honor, but I'm trying to give you clear information, but you're not letting me tell you what's clear and what's not clear. What do I do? I don't have an attorney.
Do not try to tell me that I don't give you an opportunity to. If you would just listen, then there would not be a problem. But you are constantly talking about something. You interrupted Ms. Hart. You just constantly are interrupting. I'm trying to explain to you that I'm denying your motion. I am telling you that you can satisfy the judgment by tendering the $21.15, that if there becomes an issue regarding those, that only includes an amount through August. But if you can satisfy the judgment, you satisfy the judgment. And then there may be a fight, there may be a case that comes up dealing with September, October, November. Whether you want to fight about it or not, not my issue. Motion's denied. I'm done.
Thank you, Judge.
Thank you.
What we just witnessed is a powerful example of how strict courtroom standards can outweigh personal circumstances. The judge made it clear. To set aside a default judgment, you need two things: good cause for missing court and a valid legal defense. While April Davis explained her situation emotionally, she never fully met that legal threshold. That's why the motion was denied. However, the judge did leave a narrow path forward. Paying the $2,115 could satisfy the judgment, but it doesn't erase future rent disputes. This case highlights a critical lesson. Understanding legal procedures is just as important as having the money. Now here's the big question. Do you think the judge made the right call, or should more leniency be given in situations like this? Drop your thoughts below. And if you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.